Chairman, in general, contrary to the initial legislation, there's no lifetime ban for committing a domestic violence misdemeanor. Relative to protective orders and probationary sentences, the weapon may be returned after the duration of each. The Sub-A exempts civil family court orders that were discussed in committee. Those are non-RONCO orders, but they keep them in RONCO. There's also relative to storage of weapons that will require due care, and people can petition a district court for the return of their weapon and will not be required to pay court fees and shall get a decision within 30 days. Those persons convicted of domestic violence misdemeanors that are listed will surrender their weapons for 6 years. Another domestic violence misdemeanor will create a total surrender timeline for 12 years. The third one becomes a felony, and felonies have a lifetime ban. That's just an overview. I can go through each section.
Yeah, I think to the extent you can, Mr. Manning, as you can would be appreciated.
Yes. On page 3, lines 15 and 16 were added, and that language is the person required to surrender their firearm pursuant to the section shall not be responsible for any costs of storage or any firearm surrendered pursuant to this section. That's an area that was raised at the hearing. On line 21 and 22, nothing in this section shall be construed to limit, expand, or in any way modify orders issued under Rhode Island General Law 15-519. That was raised in the hearings. That is the restraining order under divorce treatment for harm and menaced spouses.
That's in family court, right, counsel?
Yes, that is family court.
That's what we refer to as the magistrate shepherd special in the hearing. Is that correct?
Well, pursuant to the statute that is cited, 15-519, that's pursuant to the divorce section of the statute. And there's language in here relative to that other section where magistrate shepherd heard. And I'll get to that. That
okay, I'm sorry to interrupt.
No, I'm sorry. Relative to page 4, Rhode Island General Law 1147-5, possession of arms by persons convicted of a crime of violence or who is a fugitive from justice. That lists the persons who are not able to purchase, own, carry, transport. Relative to domestic misdemeanors, that's subsection 4 on line 28. The enumerated domestic violence offenses are simple assault, cyber stalking and cyber harassment, violation of a protective order, and disorderly conduct. Convictions, and there's a caveat with that, only if that disorderly conduct offense involves the use or attempted use of force or threatened use of a dangerous weapon. So, also on page 5, lines 3 through 7 were added, and that indicates that the provisions of the subsection shall apply to all persons who enter a plea of nolo contendere or have been convicted of any offense specified in that prior section I just read, and or felony domestics, unless and until that person's matter has been expunged or upon the completion of the sentence of a 1-year filing or the end of 1-year probationary period, which no longer constitutes a conviction pursuant to 1218.3. So the prohibition is for 1-year filings, a probationary period that is successfully completed and no longer constitutes a conviction. In addition, on page 5 at the bottom, 1147-5.4 is a statute that deals with surrendering of firearms after domestic violence offenses. That goes on to the next page, in sections line 25 through 34 were added, and that is a procedure that the Rhode Island State Police are going to develop relative to firearms that have been deemed abandoned. And it lists certain criteria. If 6 years have passed from the date of the completion of the defendant's sentence for an offense that was previously stated, a person can apply to get that gun back and reclaim that firearm. There's notice provisions that were added, and in the end, if that person does not make claim for that firearm, it's deemed abandoned, and the state police can take action to destroy or sell the firearm, and any disposal, lest the costs are given back to that person. And on the bottom of page 7, line 34 was added. Well, it wasn't added, it was changed, that the domestic violence, the convictions of domestic violence that are enumerated, whether as a result of a plea or a conviction, the prohibitions that are listed from purchasing, owning, carrying, transporting, and having in their possession any firearms. So the section earlier that said what the misdemeanors were that were enumerated, and the 1-year prohibition for a filing, the 1 year for a probation that's successfully completed. In addition, on page 8, lines 5 through 34, that whole section was added. And this has to do with the court notifying a person on a plea of nolo contendere of their collateral consequences of the plea of guilty, i.e., as it relates to not being able to purchase, own, carry a firearm. In addition, at the sentencing of a person on a felony, the court is to give them these collateral rights as well, advising them that they will lose their privilege. On a felony, it's a lifetime ban for a conviction.
So when you plea, according to this, the judge will tell you, you understand that you're going to lose your right to guns.
That's
if you
correct.
take this plea.
Yes.
Okay.
And on the felony, it's a lifetime ban.
But not on a misdemeanor.
Not on a misdemeanor. And in addition, there's some language added that the person required to surrender their firearm shall not be responsible for any costs of storage. At the bottom of page 8, lines 29 through 34 were added. And that is also that the court, it's additional language, that the court, for misdemeanors, has to notify the person pleading of the collateral consequences of a plea. Moving on to page 10, which deals with Rhode Island General Law 1515.3 protective orders. On page 10, line 15, there was some language that was added. If someone goes in for a protective order in which the person to be restrained appears, the court shall inform the respondent before any agreement to have the order entered by consent, with or without any findings of fact, that the respondent shall be subject to the surrender of firearms provision. So that addresses that issue, Chairman, that you raised earlier. If one person goes in for a consent, or they have a hearing, or go in on a hearing on a restraining order in Magistrate Shepard's domain, that they are to be informed that if they agree to a restraining order without facts, that in fact there are collateral consequences which are listed in this bill. So that addresses the issue that was raised at the hearing as well. Relative to in addition to that section 1515.3 concerning protective orders, on page 11, lines 11 through 13 were added. And it wasn't added, the language was just changed, that a law enforcement agency in the possession of the firearm has to make the determination that the person formally restrained under this section is not otherwise prohibited from possessing a firearm under state or federal law. In addition, lines 18 through 30 were added, where the law enforcement agency in the possession of the firearm, if they don't return the firearm upon the expiration of the protective order, the respondent can file a petition with the family court seeking relief to get that firearm back. There is to be a hearing scheduled within 30 days upon that request, and there is to be no filing fee for that request for the respondent seeking the firearm back. And in the event the family court makes a determination that the relief should be granted and they grant a motion to return the firearm or lift the firearm prohibition, they will give notice in writing to that person as well. Finally, Rhode Island General Law 1147.5.5 was added. That's on page 12. And that's relative to a motion to lift firearms prohibition for persons convicted of specified misdemeanor domestic violence offenses, and it lists consecutive prohibitions and return of surrendered firearms. So that's the section that indicates when a person can otherwise get a firearm back. So if you go to the last page 13, so a person's not eligible for relief until a certain period of time has gone by. If a person is seeking to, after a year filing or the completion of probation, a person is eligible to seek relief to get that firearm back immediately. If there is a conviction, they have to wait 1 year for the sentence that sentence to be over, and then 5 years from the date of the completion of the sentence. The only way it would be less than that is if it's the 1 year filing or the 1 year probationary period. In the event a person gets another enumerated domestic misdemeanor pursuant to subsection 4 of the chapter, then they get an additional 6-year firearm ban that they can't have firearms. If it happens a third time, it becomes a lifetime ban. The statute also sets out a procedure for the filing of the motion seeking relief. There's no fee charged. The district court shall hear it, or the court having jurisdiction will hear that within 30 days. And when if in fact it's granted by the court will issue a notice that it's granted, and that person can bring that notice to the authority that's retaining the firearm. And finally, if the court grants relief that doesn't constitute an expungement or any way relate to the charge itself, it just indicates that they've successfully completed and met the criteria to return the firearm. Those are the changes that have been made to the bill.